Okay, I'd like to call the meeting of Tuesday, August 15th to order. And I'd like a motion, first of all, to go into executive session in accordance with Mass General Law, Chapter 30A, Section 21A, Exception 3, to discuss strategy with respect to collective bargaining or litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body, and the chair so declares.
So moved.
Second. Yes.
Yes.
Yes?
Yes.
Yes. Okay, and we will be returning to open session as soon as the executive session is over. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We'll begin the meeting with a moment of silence. We should obviously keep in our thoughts and prayers at this time the people of Charlottesville, Virginia. Meetings being recorded and televised by a local cable company. I'd like a motion to approve bill and payroll warrants.
So moved.
Second.
Any questions? All those in favor?
Aye.
Motion to accept correspondence in the read file.
So moved.
Second.
Any discussion? All those in favor? Approval of meeting minutes, open session, June 20th, 2017.
So moved.
Second.
Any questions, discussion? All those in favor?
Abstain.
And open session, July 18th.
So moved.
Second.
Questions? All those in favor?
Aye.
Aye.
Let's do a couple of things before 7:05 shows up. Act on the disclosure of municipal employee of financial interest in a municipal contract as required by General Law, Chapter 26(8)A, Section 20B for Planning Board member Kim DeMello. Kim DeMello. How do you pronounce her middle name?
I believe it's Wajula.
Okay, Kim DeMello.
She is a member of the planning board, and her husband has entered into contracts with the Public Works Department to do road work, so
Okay.
the disclosure is necessary,
Okay,
if the board is to permit it.
okay, is there a motion?
So moved.
Second.
All those in favor?
Aye.
Act on the recommendation of the town administrator to appoint Robert S. O'Rourke to the position of sealer of weights and measures.
So moved.
Second.
Any questions? All those in favor?
Aye.
Act on the recommendation of the Deputy Chief Hanlon to appoint Mary Kochi, Diane Darcy, Jody McKim, Jane Ploss, and Patricia Redfern to the position of matron for a one-year term through June 30th, 2018.
So moved.
Second.
Any discussion? All those in favor? Take action to authorize the town administrator to enter into an intermunicipal agreement with the Brockton Area Transit Authority for the use of a 2017 Ford E350 gas type C paratransit van. That's a big mouthful. To be operated by the Council on Aging for the purpose of transporting elders and disabled individuals as specified in the Town Mobility Assistance Program application. Is there a motion?
So moved.
Second.
You want to say anything about that, Frank?
Just that this is the third opportunity Whitman has had to receive a new transport bus from Brockton Area Transit through a regional grant. While they call it a lease, it's really more of an intermunicipal agreement, since we don't make any payments on it.
Okay. All those in favor?
Aye.
September meeting schedule. Anyone have any suggestions? When we should meet in September? You're gonna be laid up for a while, right, Dan?
Yeah.
Is there a,
Well, August 29th, I'm having my operation on my knee, and they're saying 3 to 4 weeks laid up.
okay, so we
I mean,
just can't count on you for September probably.
well, let's say my wife pushes me in a wheelchair, maybe we'll see.
How about 12?
Well, you'll have a walker by then.
Pardon?
Yeah, hopefully, yeah, listen, I'll give my
26.
best to work it.
12 and 26?
Yeah.
All right, let's try 12 and 26. September 12th and 26th, it's fine.
9/12/9/26.
Okay, we've reached 7:05. Public meeting with respect to the application of Memorial Field Association Incorporating to a business as American Legion Post 22 for new officers, directors on the premises located at 33 Legion Parkway. Frank, you want to say anything about that?
Sure. The changeover is simply to appoint a new slate of officers and manager for the all alcohol beverage license.
And I might as well read them. Clarence Walker, Director, President. James Murphy, am I reading the right list? Director Treasurer. Paul Hanson, Director Clerk. Phil Jubert, Director Assistant Clerk. Ralph Quimby, Director Manager. George Lopes, Director. Richard Cameron, Director Vice President. Walter Aylward III, Director Vice President. Ellen Souza, Director. Bruce Smith, Director. Is there a motion?
So moved.
Second.
Any discussion?
I have
All
no
those in
problem.
favor?
Aye, I have no problem.
It's not 7:10 yet. So we'll just,
Working too fast.
why don't we, yeah, you guys are done.
Something we said?
Okay.
Didn't say?
What?
Something we didn't say?
Yeah, I don't know. We usually go around the board at the end of the meeting. Is there anything you want to say right now, Frank, for,
Sure, a couple
that
of
purpose.
things.
just to kill 3 or 4 minutes?
The
No more than 3 or 4 minutes?
I just want to note that the Council on Aging, we've talked about this a little while ago, but not at a meeting, has changed its public hours on Tuesdays to 7 p.m. And the reason for that is they are reaching out to the senior and younger senior community to say, come on in, meet us, socialize. They offer a light dinner, soup, sandwich, and snack on those Tuesday nights, and so far they've been pretty well received.
How well attended have they been? Or how
The-
has the attendance been?
Last time I talked to Barbara, she had, I think, either 14 or 15
Oh,
people stop
Good.
in, and that's a crowd for that group right
Yeah.
now.
okay.
We're in early stages. I actually had asked, and I may have that number here now, I asked the town clerk to pull some information for me out of the census. We have 3,109 people over age 60, which is the age at which the Council on Aging begins to reach out. I am not sure if this is inclusive or in addition. We have 2,187 people over 65.
Yeah.
So we have a pretty significant pool of people that may have some interest in participating in the senior group. Lord knows, I've been hearing about a new building since 2007, and maybe someday we'll be able to look at that a little more practically. Second item I have is the town declared a surplus, and we're offering for auction an ambulance and a fire truck, pumper. Last week, the superintendent of public works contacted us and requested that we consider transferring the 2000 ambulance to the public works department to be used as a utility vehicle as opposed to auctioning it.
That's a box truck.
What was our last offer, 2,800? 3,100. I called Bruce and asked him if he wanted to make a better offer. He didn't call me back, so I guess he didn't get the humor of my call. But in the meantime, I would ask that the board consider removing that from the surplus vehicle list and transferring that vehicle to the Department of Public Works.
I'll make that motion.
Second.
Any discussion?
Yeah, Frank, are they going to clean out the box end of it to be used for what their purpose is?
Yes, actually, Chief Greno mentioned possibility of us picking up an additional body, a utility body,
Oh, thank
that
God.
can go on that chassis, so we're gonna look at that as well.
Yeah.
But this would be helpful to them, and they've agreed to surplus 3 other vehicles to balance the fleet.
Okay. All those in favor?
Aye.
Aye.
Anything else, Frank?
That's all I have.
Thank you. 7:10. Time for a public hearing with respect to the petition of the Massachusetts Electric Company and Verizon New England Incorporated to relocate pole number 14 on Washington Street, 15 feet north of existing location in support of the new underground development on Rose Way.
So moved.
Okay, well, the meeting is open. Frank, would you want to introduce
Talk
this?
slowly.
Yes, I know Steve Egan, who's the developer, could not be here tonight, and it looks like National Grid may also, National Grid is here. This is a fairly routine request. We have a pole that, as a result of the development, you can step right up here, sir, needs to be relocated in order to make room for access to the development. In Whitman, I believe National Grid handles all of the poles.
Yep, we have a new policy with Verizon, and we're going to be installing all the poles, and Verizon will be removing
Yeah, I
all
saw
the
that.
poles.
Right in the middle.
So I would recommend that the board approve this relocation request in order to accommodate the development.
Okay, motion,
So moved.
Second.
discussion, all those in favor?
Aye.
Okay, thank you.
Thank you.
Thanks for showing up.
Yep.
Well, that was a quick hearing.
It was.
No controversy.
The next item on the agenda is the 7:15 disciplinary hearing with respect to O'Toole's. Is everybody here? Do you mind starting 2 minutes early? Okay. Okay, Matt? Be my guest.
I just thought that was one cattle. I just thought that was one cattle.
Okay, Frank, would you or Matt like to introduce this, this topic?
Yes, this is a hearing that was originally scheduled, I believe, in February. But due to a number of issues, we have had to postpone the hearing. It relates to an incident that occurred in January at O'Toole's Pub, where an individual was injured in a fight between two patrons. And the board is now hearing from the licensee as to what occurred and why the event should or should not be found to be in violation of his all-alcohol license.
And if I could just add to Frank's comments, the original notice from the board was dated 3/31/2017. The board voted on 3/28/2017
I stand corrected.
to notify Mr. O'Toole of the
Is that the right way?
You guys are gonna have to share it.
The board voted during its meeting on 3/28 to notify Mr. O'Toole of the alleged violations of his liquor license and that the board had scheduled a disciplinary hearing. It has been rescheduled a number of times. Most recently, by a notice dated July 31st, 2017, a supplemental notice was issued to Mr. O'Toole at the request of his counsel. That letter should be in your file. It's a 9-page letter addressed to Mr. O'Toole, to Mr. Flanagan, who is counsel, legal counsel to Mr. O'Toole, and it was captioned supplemental notice of hearing in response to request for additional information. This correspondence was in response to a request before the last scheduled hearing on July 18th from Attorney Flanagan for a more definite statement of the allegations against O'Toole's Pub. The letter was, again, without limitation of the effectiveness of any of the prior correspondence. A supplemental notice was issued on July 31st. With that notice, O'Toole's Pub was provided with a list of proposed exhibits, given copies of all of those exhibits, as well as audio tapes and a copy of the videotape of the incident that, in my understanding, was produced in the first instance by O'Toole's Pub to the Whitman Police Department. So for purposes of tonight's hearing, O'Toole's Pub does have all of the exhibits that have been provided to the board for its consideration, inclusive of all audio and video files. O'Toole's Pub has also been provided with a copy of all potential witnesses to tonight's hearing that may be presented by the town, and that list includes representatives from the Whitman Police Department, including Chief Fanton, your town administrator, Mr. Lynham, as well as Fire Chief Timothy Brennan. I did have a brief conversation with Attorney Flanagan when I arrived tonight. He did indicate that he has no need for Chief Brennan's presence here tonight. He will stipulate as to those documents and exhibits that have been identified to date that have been generated by the Whitman Fire Department. And I have those items identified as exhibits 5 and 6 to notice that was provided on July 30th. So unless the board has any need to hear directly from Chief Brennan, I would suggest at this point Chief Brennan could be excused from the meeting, and the board can simply take into account the reports and the audio files that have been produced by the department today. I leave that to your discretion. I have no fear.
Okay, I have no problem with letting Tim go.
No.
And the notice that has been provided to Mr. O'Toole does note the fact that he's got the right to be here tonight, to be represented by counsel, and that he does face the potential for discipline. The notice also cites a prior disciplinary event that has occurred that was before this board within the past 4 years, and the fact that the town does currently have liquor licensing rules and regulations, and those are specifically cited in the letter to Mr. O'Toole, the notice of potential discipline, and the fact that prior discipline within the 4-year window is something that may be considered by this board, consistent with the rules and regs, consistent with the board's authorities under Chapter 138 and Chapter 140 of the general laws of the Commonwealth, in determining what, if any, discipline is appropriate based upon the incident that occurred on January 6, 2017. So that is a further overview of the procedural history of this matter.
I don't have any objections to the exhibits being admitted. I have some copies of the decision back in December 2015, which I highlighted some areas of the decision. It's going to be a part of my argument that I'd like to pass out to the board, if that's agreeable.
Yeah, be my
Show
guest.
it to council. That's all of us. That's all. And that's a part, that's an exhibit as well, I believe.
It is an exhibit to, I think it's an attachment to Chief Benton's original communication to this board, referring the matter for possible discipline.
Pass it out. Just
That would be the February 23rd letter.
Well, he's going to give us copies anyway. Thank you. Thank you.
Thank you.
The only purpose of that, gentlemen, is because it's a lot to read, short hearing, relatively short, hopefully. And I just highlighted some areas that I may talk about, and I'll say what page I'm talking about. And you can certainly feel free to take as much time to read the entire decision while we're talking about that issue, or the highlighted version that we're talking about.
Okay, fine.
And one other note, just
I
in
did have
terms
it.
of evidence here this evening, there is a videotape of the incident. And in speaking with Mr. Lynham, we do have concerns that displaying that video in open session would likely offend the privacy interests of those parties depicted by that video. So I think at some point during this hearing, the board may have the need to view that tape, and it's brief, but in executive session, again, in order to protect the privacy interests of the two parties who are, at least the two parties who are depicted by that.
Okay, if there becomes a need to see the video, we'll go into executive session and deal with it that way.
I don't object to that as either, but I would like that video shown to the board.
You would,
So that's-
okay.
Yes, and it makes sense for the board, if they're going to do an executive session, to do it prior to any witness testifying, because then it's referring to
Actually,
the video.
It does, we should probably do it
You've
now.
seen it, okay.
We should do it first. I'd like a motion to go into executive session.
So moved?
Second. Yes.
And the reason to go into executive session is to protect the privacy of the people who are maybe depicted on this video.
Yes. Yes.
Yes.
Yes. Okay, are we ready to go back? Okay, now that we've seen the video of the events of that evening, Nat, I'd like to turn it over to you to present present what you'd like the board to consider.
Can I make a motion before you call your first witness?
Can you make a motion?
May I, I'm asking you before you call your first witness, may I make a motion?
I'm sorry, I'm not hearing you.
Yeah, I was asking my colleague if I can make a motion before he calls his first witness. We can do that. I'm asking to make a motion at this time.
Sure.
Okay. If we could ask all the witnesses not to use any names, first or last names of the people that are involved, to protect the people that are involved in the altercation. We all just viewed a video of an altercation and
Right.
the ongoing criminal proceedings. Ask if all the names not be used. They're redacted on the exhibits.
Right. Is there any way that someone watching this broadcast can figure out who the people are by what your witnesses are going to say? If that's the case, then they should be here.
I'm not sure I understand.
It's an open session.
Yes.
If we're going to be, if it becomes clear to anyone watching this video that he or she is being spoken about, whether the names are mentioned or not, then that person has the right to have notice and to be here.
And furthermore.
It's not enough just to not say their names.
Right.
If someone outside there can figure out who y'all are talking about, then they have the right to notice and to be here.
So to answer your question, I don't think anyone that was not present at O'Toole's Pub would be able to figure out from that altercation who the people are. And anybody who was at O'Toole's Pub had firsthand knowledge of what went on.
Mhm.
So that's irrelevant.
Well, I'm not sure it's irrelevant. Matt, you know you agree.
I agree. So,
You agree with what?
I agree with what you are saying relative
Okay.
to anyone who may be identified either directly or indirectly by any of the testimony given tonight. Attorney Flanagan is correct in stating that the records that have been produced for purposes of tonight's hearing have been redacted
Right.
for the obvious purpose of protecting the privacy interest of any parties identified by those reports. We also have viewed a videotape of the incident, and that was done in executive session, again, for the specific reason of protecting the privacy interests of any parties involved. But if any of the testimony or evidence presented tonight, either indirectly or directly identifies anyone, then they are, of course, entitled to receive advance notice and an opportunity to be here.
Right.
And so I think it's a valid concern. Attorney Flanagan's response is that he does not anticipate
that anyone will be identified. I can't speak for him, I'm only,
Except for the back.
I'm simply asking the witnesses not to use any names. I don't think that request is protecting both interests here.
Well,
And more importantly, the people that are involved in the altercation, who may have criminal proceedings still ongoing. Protects the police department, protects the DA's office, protects the people involved.
I don't disagree with any of that, but at the same time, it does raise the issue if we are concerned with their privacy interests, whether or not, in order to fully protect their privacy interests, whether they should be at least afforded an opportunity or provided notice of this matter and an opportunity, if they so choose, to be present. I can't anticipate what their response would be. I don't know if anyone would choose to attend for that purpose, but it does raise an issue as to whether or not they are at least entitled to notice of the hearing, given the concerns about their privacy interests. And we have not encountered that issue before directly in the context of one of these
right.
liquor license disciplinary hearings. But we do, as I understand, have an ongoing criminal case. And we certainly have at least two parties who were involved in the incident. And we're going to take all precautionary measures to protect their privacy interests. Whether that should also include advance notice of the hearing is something for your consideration. Because I can't anticipate what all of the testimony is going to look and sound like.
Well, that's what was a red flag to me, because I'm not sure.
I understand.
You know, you mentioned that they were going to not mention their names, but it is possible for someone to figure it out
Sure.
if they know of the events.
I understand that. It also was a public hearing, so the public had notice of the hearing.
That's true, they did.
fair
They
point.
did.
Yeah.
So I suppose they could have been here if
wanted
they
to be
if they
here.
wanted to.
I think everybody in this room's intention is to protect their interests,
Yeah.
and everybody's interests. So,
Well, I do think that irrespective of the fact that this is a public hearing and there was public notice, there is still a requirement under the open meeting law to provide notice. So the fact that a meeting is publicly posted does not eliminate the necessity to provide notice to someone who may be discussed, whose reputation is.
That's
So it is,
That concerns me.
it is a valid concern.
Does it concern me enough to want to postpone this until they get notice? I'm not sure. I could ask for some advice from you or from how the rest of the board members feel.
I don't know. What do you think?
When is your next meeting?
It is on
September
September 12th.
September 12th.
September 12th. The event happened in January, right?
I did, and there's been several efforts.
No, I know there've been a number of efforts to have a meeting, and we haven't had
Right.
one yet. So we have you all together now, this is great, except I was at an open meeting recently at another place where there were events that were discussed in that open meeting, and people didn't say the names of the people that were involved. It would have been clear to anybody who reads the Brockton Enterprise who they were talking about. And it just became very clear to me that that was a violation of an open meeting law. And I just don't want to do that here.
okay. I'd like to have the
Mr.
hearing.
Chairman, can I ask a question?
Yep.
Do we have the names and addresses of all the persons who were present in the bar at that time, so that we have the ability to give them notice?
We don't. O'Toole Spot does not.
No, but the witnesses know who they might be not mentioning by name,
Absolutely.
right? So we can obviously do some homework and reach out to those people. You know who they are. The witnesses know who they are.
My primary concern would be the two involved parties, because one is, currently as I understand it, subject to criminal prosecution. The other is at least an alleged victim of an assault. So I think that both parties, those are the parties that I am primarily concerned with in terms of
It's like I'm gonna have to
protecting
help you quick.
their privacy. Other parties who may be in the bar as patrons that night, I suppose they also are witnesses to a potential crime. So I think that if we were to provide notice to parties, I think we would endeavor to provide notice to everyone who was present. And is that,
No, let me know.
Is that possible to do?
1 week?
I mean, the videotapes.
If we were to do this on the 12th?
I'd have to look at my calendars and my phone, so
No,
I can do that for you.
that's fine, but
I don't know if that, I'm available on the 12th.
Yeah.
And this is your area, not mine, so our position is, we're here, we'd like the hearing tonight. I understand your concerns, and it's really, we really don't have any standing in this issue. This is between you guys. I can look at my calendar and see if I'm available on the 12th, if you do make that decision. I don't know if the decision has been made.
Well, the decision would, if we decide, the decision would be to reschedule it at a time when we could do it. And when the people that I'm concerned about are told that they may be mentioned in a meeting.
Because they would have the right to assert that that portion of the meeting be conducted in executive session. That would be the difference.
That's
We
the issue.
cannot,
That's the issue,
Yeah?
the right to be in executive session.
now they may waive that right, but it's theirs to assert, not ours to deny.
Well put.
And so that is, again, given the fact that you've raised that as an issue, and I think it's a well-founded concern, I think it probably makes sense to at least attempt to notify anyone who may be referenced during the course of this.
He won't be here.
You guys all right with that?
Well, yeah, and then one of the people that are involved as a witness is not present because they are not available, may be available at our next meeting. You know what I'm talking about?
How much notice do they need to get?
48 hours.
So if we postpone this hearing for 1 week, that way Mr. Salvucci could attend because he will not be available on the 12th. It would be nice to have.
Unless I heal quickly.
Yeah. I'm not gonna be available on the 22nd.
Yeah, I'm not either, actually.
He's not here.
It was a nice effort
Hey,
anyway.
maybe I'll be ready the 12th.
Maybe?
Or we could put it to the 26th. There's a real good chance you could be ready for the 26th.
Yeah, better chance, yeah.
I mean, the incident happened when?
January.
January?
I mean, yeah,
I'm not gonna worry about another month before we have this hearing, if we can avoid
lawsuits.
what I hope I'm not exaggerating as a danger. Well, we know that we're meeting on the 12th and the 26th. Why don't we?
Work within that time frame.
Yeah.
I cannot do the 12th.
Okay?
About 26th.
'26 is available for me.
Okay.
Not available on 26. Sorry, gentlemen, I'm not.
Can we do it now?
What?
We do it now then?
No.
Take the chance now?
No, I don't want to do that.
Can we put it off to Attorney Tobin and I to get our calendars
Yeah,
together?
Okay.
that'd be fine.
We can have a different, I
That'd
don't
be
want to
fine.
set your meeting for you, but does that make
Yeah,
more sense?
that'd be fine, and we could do it on an off week.
So you can do it in an off week.
Yeah, we could do it
Yeah.
we could do it by itself.
Or can we do that? I mean, we all have our calendars. You want to,
Yeah.
cannot do 12 or 26, 19?
Probably the 19th,
September?
19th of September?
Works for me.
19 is fine. It's a,
And the meeting would be for this purpose only?
Only.
Right, exactly.
Okay.
The 19th of what?
7 o'clock on the
September.
19th.
19th of what?
September.
September.
You can make it.
I think we should
You're a
discuss
tough bird.
how we're going to do notice, Mr. Chairman.
Well, the notice has got to come from the board. And it's a notice under the open meeting law that advises individuals that they may be discussed at an open meeting.
So it will be up to you to get
Our full
whatever
list.
people you were thinking your witnesses might be talking about without mentioning their names, to get those names and addresses to.
That's, I don't believe that's my responsibility. The names are in the police report. They've been redacted. Mr. O'Toole knows some of the names, but that's not what I'm talking about. I was anticipating police officers possibly using names. So the names are in the police report.
Right. We can pull
Well,
that.
so
All right, I don't care where you get them.
We can
we need to
use
get
that
those
for
people.
notice, as long as everyone that you believe would be referred to is in that police report.
I don't know. That would be up to you guys. You're putting on your case. We're defending you. Well, no disrespect at all. I don't know any of the names. All the names have been redacted. I haven't received one name on a police report.
Well, I think for the purpose of addressing this issue, we could provide a key of individuals, and I'll have to check with, again, there are concerns because it's an ongoing criminal matter. But we'll have to discuss, I certainly can speak, I will be able to speak to the issue of who the Whitman Police Department would identify directly. You think that there would only be parties, though, identified by the police reports?
Correct. That's all, the only people I'm talking about.
Okay. Okay. So I think what I could probably construct is a list of possible either participants and/or witnesses to the events of January 6th,
Okay.
without identifying their role.
Okay.
And then you could identify whether or not you would be presenting any testimony relative to any of those individuals identified. Does that sound reasonable?
If they're my witnesses, absolutely, I'll let
Yeah.
you know. Absolutely. If
Okay.
they're my witnesses. If they show up
Okay.
and they want to testify, they're your witnesses, they're not mine.
No, I know, but you could have one of your witnesses testify about some other party.
Yeah, rebuttal, yes, I understand.
That was your original point.
Not necessarily.
Well, that's what it seemed
I think
like.
we're going around, yeah, I think we get it down.
You think you guys have got it straightened out?
I think so.
Okay.
We'll straighten it out.
Yeah,
All right.
that's fine.
19th, 7 o'clock?
That's fine.
Okay.
Okay.
Sole item. Sole item.
Yes, sole item. No exceptions to that.
So you need a motion to postpone this hearing?
Motion to continue to,
Sure.
since we
A
already...
motion to continue this up until September...
On September 19th.
On
7
September
o'clock.
19th.
Gentlemen, procedurally, we've already had some new testimony, but some argument, some motions, and an executive session. Are we starting over from the very beginning?
No, that's why
September
we're
19th?
continuing the meeting.
We're continuing the meeting.
Gotcha.
Yeah.
So that in terms of the video,
We don't have to see the
No, we've seen
you
it.
don't have to see it again?
No, it's right, it's here.
Thank you.
Okay.
I'll second that.
Okay,
Yes.
All right, so I'll be in
Yes.
contact.
yes.
Yes.
Actually, we didn't have to do that because we weren't in an executive session. All I needed was vote.
Oh, yeah, yes, there we go.
Okay, thank you very much for coming, and I'll look forward to seeing you again. And I think that we're done, right?
We've exhausted the agenda.
Exhausted the agenda. A motion to adjourn is in order.
Motion?
Second.
All those in favor?
Aye.
We're out.